Alex here with part 26 of the My Docket series on Corazon real estate. We are about to go into the reply memorandum in support of the motion. So this is basically a reply to opposition filed by the attorney for Corazon real estate. My mindset was still probably frustrated and annoyed, and I don't imagine that at the time I had any reason to think otherwise. I definitely don't have as strong or vivid memories with regards to this dispute in comparison to my high confidence child custody case, but that makes sense because the kids are different. So really, it's going to be one of those videos where we go straight into what Corazon Real Estate's attorney has filed. Here we have the reply in support of defendant's motion for judgment on the pleadings. Standard introductory paragraph indicating this document was filed, let's see, through, Thorndall Armstrong. In support of the motion for judgment on the pleadings, they're going to attempt to address the major issues of law and fact. The failure to address any specific issue of law or fact is not to be taken as an admission. They attempted to dismiss proceeding pursuant to 12 sub C. C, it's a motion for judgment on the pleadings. They demonstrated they're entitled to judgment because the claims fail as a matter of law. Again, yeah, this should be okay, I'm not going to talk about it again. Plaintiff filed opposition to the motion. Layperson proceeding pro se. Comprehensible brief containing citations, which I did do. Plaintiff's opposition is a collection of random thoughts which misapply the law. The only place where I would agree with that is the conversion point. Devoid of substantive legal arguments. This is a typical tactic that attorneys use. They try to use derogatory language against pro se litigants. I mean, matter of fact, that's one thing. But to try and argue that the whole thing doesn't make any sense isn't true. Those cases are actually Nevada cases that control. The last guy who did this got overturned. You remember Charles Chinichi said all the same stuff. Didn't matter. He was wrong. Dismissal of plaintiff's complaint is proper under 12 sub C. Let's see. Corazon's motion for judgment on the pleadings can be construed as a motion to dismiss. Evident that the plaintiff has a fundamental misunderstanding of 12 sub C. Okay, says the defense who's filing a motion for judgment on the pleadings. A plaintiff's mechanism. In any event, in the interest of judicial economy, they'll not rehash the appropriate standard. Repeated motions filed. It bears repeating that motions filed under 12 sub C are appropriate for disposing cases. Early, yeah, this is early case termination stuff. That's a video that I did. It is a rare procedural mechanism because it's used by plaintiffs when the defendants admit a bunch of stuff. I don't know, maybe I'm wrong, but most defendants do not file this. They just file a failure to state a claim. They don't even file an answer. They just fire off a failure to state a claim motion. Uh-oh. Motion for judgment on the pleadings filed under 12 sub C and motions to dismiss for failure to state a claim filed under 12 sub B are analyzed under the same standard of review because they are functionally identical. Yes, this is true. I find this very believable. So she's arguing that it doesn't matter because they go into the same analysis, which I find very likely to be true. In addition to requesting that the court construe the motion for judgment on the pleadings as a motion to dismiss. Yeah. Okay, so they're asking to treat it as a motion to dismiss, which is fine. I assume the court would do that. I'm contending that the motion could be, I don't say should be, could be treated as a summary judgment motion because of erroneous conclusion that motion incorporates matters outside the pleadings. Well, I mean, because the two things that she brought in are court filings, she's probably right about this. I'm not 100% sure, but I also find this to be plausible. Courts have specifically held that a document is not considered outside the pleadings if the complaint refers to the document and if its authenticity is not questioned. I would want to read Venetian Casino Resort more clearly to find out what I think about that. What they're trying to say is if the pleading refers to a document. See, if you attach an exhibit to a complaint, that's probably on point. That's probably true. I don't remember attaching any exhibits to my complaint though. Maybe I did. Maybe I did and I just forgot. The only documents attached to the motion are the 30-day notice to vacate and the correspondence from Corazon. Plaintiff's amended complaint makes specific reference to these documents. Okay, guys, so interesting. If I did attach those exhibits to the amended complaint, then I think that they are correct. And if I didn't, then I don't think they're correct. Okay, look, it says that, okay, so maybe my standard complaint did not include the exhibits, and then I attached the exhibits to my amended complaint. That's what they're saying here. So that's making me think that those were attached, which if that's true, then they're probably right. And I talk about this in the video, the complaint, that this is one of the perils of attaching exhibits to complaints. Please watch my video on the topic, the complaint. I probably got frustrated that this judge threw out the throughout the case the first time saying there was no evidence. And so then the second time I was probably playing better safe than sorry and thinking to myself, he erred last time. I'm just going to go ahead and attach the evidence since that's what he wants. In hindsight, probably shouldn't do that. Just because the judge screws up doesn't mean that you go outside the boundaries of the law. If you're following the law and the judge is not following the law, stay within the boundaries of the law. Don't let the judge lead you outside those boundaries. So that sounds like that's what happened here. It still doesn't change my opinion, though, that the case should not have been dismissed. So let's continue. Okay, and this is the other point she's making, which is that they're actually filings anyway in the court, which if I remember correctly, they are. And so it makes me think that in a sense, there's probably, it's still a stretch. It's still a stretch. I'm going to continue on because I think that they were attached to my amended complaint anyway, which is what she indicated. So it's not worth arguing over. Improperly relies upon matters outside the pleadings and evidence which is inadmissible in the opposition. That would be true for the failure to state a claim stuff, but that would not be true for the summary judgment stuff. Unless they're going to say it's not authenticated. Let's see. So they're just disregarding the summary judgment arguments, which is fine, because that actually hurts them more than it hurts me. Counts 1 and 2 of the amended complaint fail as a matter of law. So again, they're really hammering on the fact that if you are not actually evicted, then you can't bring up the. But that's, I've already talked about it in the opposition. The statute says otherwise. The statute only says they need to threaten or actually bring. It doesn't say that they actually have to succeed. So when it comes to retaliatory eviction, this argument is wrong. When it comes to wrongful eviction, it might be right. What attorneys told me was that it's not, but I didn't cite any cases in my opposition, which is a huge problem. This is just a really long, drawn-out argument of what I just told you guys. All of these pages. The landlord may not, in retaliation, terminate a tenancy. So, okay, it's nice that she's pointing out that maybe it has to be alleged that it was a retaliation. Landlord sort of eviction has to be retaliatory. So maybe they're trying to say that since I didn't allege. Okay, yeah, that's what she's saying. So, yeah. They're trying to say that I need to allege that. Well, if that's the case and it's not alleged well enough, then I did say that they can allow amendment, which is very normal, pretty standard stuff. Okay, so she's trying to argue that the actions as represented in the opposition indicates a demand was not motivated by a desire. This is too much of a stretch. They're desperate to dismiss the case early on, and they're taking a lot of liberties. It would be a much closer call under summary judgment. And in her own reply, she argues that the use of the summary judgment mechanism is not what they want to do. But that's going to actually open way more doors for them and bring them a lot closer to succeeding. By refusing to consider this under summary judgment, they're making it harder for themselves. If you want to learn more, watch my video on the topic mid-case termination. Failed to maintain dwelling units. It feels like, what is this about here? No factual allegations in the amended complaint which support the element that Corazon failed to maintain the former residence in habitable condition, as phrase that has been defined by the law. The only thing I can say is it's still a little bit murky to me as to how I drafted the complaint. And I did a video called The Complaint, which is extremely important for people to watch if they're going to try stuff like this, because it really kind of helps you get your head around how the complaint is supposed to look and what the point of it is. She may be right that it's not clearly stated that this law has been violated in the complaint, which, if you don't know what the point of a complaint is, you are very likely to make mistakes like this. Once you learn what the point of the complaint is, it all starts to click and you realize why you have to allege things a certain way. It all comes together. But otherwise, if you don't know what you're doing, you're just going to assume it's just another court paper. You just put in there your side of the story and move on. But it couldn't be further from the truth. That's a very important court paper. It's the pleading that sets forth the boundaries of the case. And it does have to be clear, and it does have to state all of the elements for the particular claims that you're trying to get money on. Otherwise, it's going to get thrown out in the early case termination phase. Another video. Plaintiff argues allegations are sufficient to support the allegation that the former residence was uninhabitable because of issues related. A sample review of the allegations provides further credence to the position that it fails to state a viable claim. Yeah, but they're just pinpointing one specific allegation. I think there were a total of 6, 7, or 8 allegations where eventually I bring up that, so I'm not trying to collect money on this one, if that's what she thinks. So she's probably trying to confuse the judge. But there's a fact pattern here, and at the end of the fact pattern, it's still not repaired. So let's move on. The court's not required to accept claims that are implausible. I don't know what they mean by that. I'd have to read Knievel v. ESPN. No, because, so again, she's stretching. She's trying to take the allegations and fill in all these gaps, which she can't do at this, because they're supposed to draw all inferences in favor of the non-movement, not in favor of her. So she's desperate to try and get this to fit into a dismissal for failure to state a claim. Spends a significant amount of time discussing the failure to maintain the stove and air conditioner. Yeah, not entitled to recovery of damages because why did they really went all out on this reply? It's a long reply. So they're saying that if they demand reimbursement for the repairs, so she's citing 118A.290 sub 2, which allows landlords and tenants to enter into agreement which requires that a tenant perform specified repairs under certain conditions. Yeah, but what are the conditions? The amended complaint does not contain any allegations that the rental agreement fails to satisfy the requirements of that law. Well, I don't know about that, because in the opposition, contract unconscionability was mentioned. So if they're trying to say that contract unconscionability has to be discussed in the complaint, that sounds like a stretch too. I don't think so. I get what she's trying to say. She's trying to say that the contract allows them to break the law. But if you recall, the opposition comes out and talks about contract unconscionability, which would be used to nullify those portions of the contract for being against the law. So it's murky. Cannot prevail on a common law claim of conversion. Attempts to avoid dismissal. Okay, yeah, this is already something that I've agreed to. There is no common law conversion here, I don't think. Dismissed in entirety because the court lacks subject matter. Okay, so then this is going back through the punitive damages again. I wonder if she talks about the case that I cited. Let's take a look here, see if there's anything besides hot air. Yeah, this is only talking about the retaliatory eviction portion, though. Yeah, so she's just bringing up this one statute. I'm talking about the issue of forcing somebody to make repairs. She's leaving that out. And look at the language. She's not saying adamantly that you can't use punitive damages. She's saying under these circumstances, we believe. So even the lawyer knows that this is shaky grounds. They could be subjected to punitive damages. Request to amend complaint should be denied. This is super, super common. This happens all the time in cases where a motion to dismiss is filed and then the court's like, yeah, I mean, this is pretty valid stuff. You're going to need to amend. Very, very common. She says undue delay, unfair prejudice, but really the case has barely been going on since the reversal. So trying to act like requesting to amend means that your claims are completely lacking in merit. That's what she says here. It's silly because any lawyer knows that this is a super, super common mechanism or defense to dismissal. And most of the time it's allowed. The only time that it's really not is when it's futile, which means amending it wouldn't actually fix the problem. If amending it wouldn't fix the problem, then it's you just can't amend because it's futile. There's no point to it. So this isn't true. This is something that is totally available when somebody files a valid motion to dismiss, where they just say, okay, you're missing these allegations. Go ahead and amend your complaint. Add them in. Problem solved. Certificate of service indicating this document was mailed to me. And that's, oh, there's more. There's another document. Request for submission. All right, guys, you've seen these a million times. If you want to learn about the request for submission, please watch my video on the topic, request for submission. They're basically submitting to the court for consideration the briefs that have been filed. Certificate of service under Rule 5 indicating this document was mailed to me. We have one more. Supplementary points and authorities. Okay, so it looks like I went ahead and filed a supplement. This is probably something that I should not have done, and I'm going to talk about this more in the next video because it's going to go into a motion to strike analysis, and I want to go into that at that time. It's going to make more sense. Yeah, so, okay, the judge was bound by subpoena ducis tecum to provide an affidavit. He complied. Clarification on the punitive damage award. Okay, so I'm trying to confront their mischaracterization that the punitive damages are not connected to retaliatory conduct, which I guess fine, but I think I made it clear enough in my opposition anyway. Paulin v. Sutton. So this is more like a surreply. This isn't a supplement. This is more like a surreply, which isn't allowed unless the court gives leave. Huh. All I'm doing is taking a good case and just piling more cases on. It just isn't, it's not necessary. I think that I just got the reply and I thought I had to continue to respond, which is a common non-attorney thing to do. I don't think that this needed to be added. Yeah. In hindsight, I shouldn't have filed this. I wouldn't have filed it if you know, it was me now. Affidavit of Judge Mancuso. I don't know if this is actually something that I went through yet. Oh, okay, so he's provided the docket notes. Which is this is his judgment. And these are costs. Okay. He's just swearing under penalty of perjury that it was him that made these notes. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. They filed 2 documents. They were both free filings, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. Corazon Real Estate put a ton of work into that reply. The request for submission, negligible. I think 4 hours for that reply is justified. At the rate of $250 an hour, that's going to come to $1,000 in attorney fees for Corazon Real Estate. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.